Hi, everyone. Welcome to our webinar. Thanks for your patience as well. We've just been allowing 5 minutes extra time to allow people to join the webinar. So thank you for that. Today's topic is how an employee-sponsored visas could be your workforce solution. My name is Roosevelt. I'm the principal lawyer for Sydney. No border. We have two offices across the country. So we have one here, one in Queensland and one in Adelaide. So I'm the principal solicitor here in Sydney. So just a little bit about ourselves first. Sorry, I'm just enlarging here. Okay, yeah, better. We are your trusted visa experts with over 27 years of experience. We're founded by Agnes Kemenes, who arrived in Australia from Hungary in 1987. What we do at NB Migration Law, we offer a range of services to cope from complex requirements our clients have within the migration landscape. And with a wealth of experience, we can provide the necessary expertise to help you navigate this difficult visa application process. What we do, because every visa we help secure a story of hope, opportunity, and a new beginning. At NEB Migration Law, we do what we do to guide individuals and families through life-changing journeys. As you can see on the org chart as well, we not only offer migration services, visa services. We also employ commercial lawyers. So we offer commercial law, property law, and employment. So yeah, the agenda today. It's solving Australian skills gap, sponsorship paths for employers, who you can sponsor now, visa pathways supporting employers, flexible solutions supporting employers, and critical update, right? At the end, you're going to have a Q&A session. Solving Australian skills gap. So the problem is critical shortage of qualified trades and engineer professionals preventing project completion. The reality is like local training pipelines cannot meet current infrastructure demands. Solution is a strategic use of skills in demand visa and labor agreements to plug gaps immediately. Key insight, migration is no longer just filling a seat. It is a retention strategy. The pathway to permanent residency is the number one incentive for global talent. So not long ago, there was employed sponsor visas. Some occupations wouldn't have a pathway for permanent residency in Australia, and this was considered to be less attractive and not an incentive for people to come here, obviously. But since December last year, they've merged the list of occupations into one big one, and all occupations on that list, no exception, have a pathway for permanent residency. So we're talking about a pool of 400 plus occupations that you can nominate your foreign workers. So two pathways for employers. So the best for is the standard trades and professionals on the core skills occupation list. So that was the list that I was referring to. It's a very big list and have a lot of occupations that won there as of last year, December. So that create more opportunities and more possibilities of sponsorship. So pros, fast processing, standard requirements, cons, rigid salary thresholds, and English requirements. So the salary threshold is reviewed every year, 1st of July, and it's increased and indexedly every year. So there was a time that it was fixed for maybe more than 15 years. And um, last year they decided to increase, they made a significant increase from 53 to 70. But now every year ever since it's just increased based on inflation, right? And cost of living. There is another pathway, which is labor agreement. That is referred as a custom solution. So specialized roles, lower English levels, or salary concessions. Construction industry labor agreements is tailored specifically for a sector to access same skilled or unique roles and not to the standard list. So if the occupation that you want to sponsor, it's not on the core skill occupation list, the CSOL, you can get into an agreement with the government, which allows you to sponsor workers who are not on the list, right? Not only that, you can have a range of concessions depending on how the negotiation goes. So you can request lower English levels, salary, experience, PR, permanent residency, and etc. So who can you sponsor now? So the standard visa sponsorships, just examples of roles you can sponsor in engineering trades. So you're looking at construction project manager, project builder. Project builder was one that was for a number of years was off the list, and the government consult industry and shareholders um, and reintroduce that occupation to the list. Civil engineer, structural engineer, quantity survey, and estimator. So those guys have been on the list for a number of years, and I don't see them being removed either. Trades as well, same story. Carpenters being always been there. So carpenter, joiner, bricklayer, stonemason, plumber, electrician, air conditioning, refrigeration, mechanic, technical. You got an architectural draftsperson, a civil engineer technician, just to name a few. But architectural draftsperson is a good example of an occupation that, as of last year, didn't have a pathway for permanent residency, and he has now. Roles requiring labor agreement, so management and engineering, so semi-skilled site roles, construction worker, concreter, earth moving, plant operator, crane, scaffolder, civil construction supervisor, not your manager, but your supervisor, steel fixers. So yeah, you get the idea there. Visa pathway supporting employers. So the 482 visa allows Australian employers to sponsor skilled overseas workers to fill positions where there is a genuine need, skill shortage, and no suitable local candidate is available. It is one of the most widely used employed sponsor visa options, if not the most one used. So how it works for employers? Employer must be an approved sponsor and nominate an occupation from the skill occupation list. Right? That's the step one. Depending on the circumstances and visa applicant nationalities and other matters, you must demonstrate labor market testing to prove genuine efforts to hire locally. Right? So job ads for at least 28 days are required before you apply for a visa. Are required to there is a requirement to demonstrate that you have undertaking labor market testing activities. The visa can be granted for up to 4 years. There was a change as well from last year, where some occupations could only get visas for 2, and some occupations could get visas up to 4. So now everyone can get a visa for up to 4 years. Benefits for employers. fast and flexible solution for filling urgent skill gaps, access to global expertise in the specialized or hard to fill roles, option to transition employees to permanent residency under the 1A6 visa after 2 years. Yeah, like I said. Supports business continuity, reducing project delays and productivity loss due to skill shortage. Okay. 42 skills in demand streams. So this visa is structured into 3 tiers based on the skills and salary. We have the specialist skill pathway, which doesn't have an occupation list per se, but there is a salary threshold and 135,000. Right? This stream offers fast tracking processing. So it's to attract high skilled workers. So specialist skills pathway. The core skills pathway, this is the largest stream for skilled workers with an occupations on the core skill occupation list and earning at least CHISMIT, which is 76,515 at the moment. The essential skills pathway is developing stream for workers in essential sectors with the salary under 70. Yeah, this part is still under construction, as they would expect from the department. They will release information and what they're going to do first before working out the details. So yeah, that one hasn't been active yet, which may or may not happen as well, because the labor agreements is essentially it's their pathway. Regional sponsor migration schemes, visa class 494. It's designed to support businesses in regional areas by addressing ongoing labor shortage. How it works: employers become an approved sponsor and nominate a role on the regional occupation list. They need to show genuine need and labor market testing evidence that no suitable Australian worker is available. The sponsored employee can work for up to 5 years and apply for permanent residency after 3 years with the same employer. Access to a wider talent of pool when local recruitment fails. These are the benefits. Greater workforce stability. Employees stay long-term due to PR pathway. Priority visa processing for regional areas, and support businesses' growth and continuity in hard to staff regions. Regional areas anywhere in Australia except Brisbane, Melbourne, and Sydney. This visa, when it was created, was to support regional areas, and because of the skill shortage there, the well-known skill shortage. But they made the requirements a bit harder to meet as opposed to facilitate them. So it's a visa that became less and less common. However, it is still a pathway, a valid pathway for certain people that otherwise couldn't get a 482 visa, right? So it's a visa that is way less common than the 482, may not even be recommended for most people, but it is a valid option if rightly used. So it was actually this week we had a client in a regional area where there were concessions available, and we applied for a 494, and he got a 494. We wouldn't get it here in Sydney. We wouldn't have a pathway for PR here in Sydney. So it's not the best pathway for everybody. But it definitely suits some people, some workers, 494. Again, they have 3 streams. The employed sponsor stream, which is very similar to a 482 stream. They have the labor agreement, where employer must hold a labor agreement with the Australian government. Specific eligibility may depend on the occupation, industry, or region. So consultation with migration experts is recommended for clarity because every region has its own requirements and own occupation list. So what it might have been true and correct for Adelaide and South Australia might not be for Coffs Harbour or the Hunter region and Gold Coast, etc. Once you hold that visa, you are allowed to bring your family to Australia. So you can bring your family, and spouse and children. Sorry. Now, employed sponsor scheme. This is also a very common visa. It's designed for businesses that want to retain highly skilled employees long term after providing their value in the workplace. So they need to have an occupation on the list. Since last year, both the 482 and the 186 share the same list. There was always been the case. In the past, they used to have different lists, source occupations from different lists. So it was very confusing. So that was one of the changes that we welcome. So basically, if your worker qualifies for the 186 direct entry, the 186, he might do that instead of a 482. Right? Bear in mind that option to get a 482 visa first and then transition to permanent residency in 2 years is still available. The benefits for employers, you can retain skilled employees permanently, reducing turnover and training costs. You can strengthen workforce stability with long-term committed staff. You can attract high caliber talent by offering a clear pathway to permanent residency. And it's very true. I'm 100% sure Australia lost a lot of talent while they had this rule where certain occupations didn't have a pathway for PR. And I'm glad that they've changed that, boost businesses' reputation as a compliant, supportive employer of skilled professionals. Okay. 186. So as I mentioned before, we have the direct entry. And these are workers who need to have at least 3 years of experience in the nominated occupation and a positive skills assessment. The skills assessment is determined by the skill assessment authority. Each occupation has its own. So that's the two things you need to meet there. The temporary residence transition stream is for workers who have held a 482 with the same nominating employer or 457 for at least 2 years, right? We put 457 there, but because they still can access PR, but I don't think they're around anymore. So, but if there is one, then they can still apply for PR. Labor agreement is for workers sponsored through a labor agreement between the employer and the Australian government, often used for niche roles covered by the standard visa programs. Flexible solutions supporting employers. Labor agreement. So labor agreement, it is a formal arrangement between an employer and the government to sponsor overseas workers for roles without suitable local candidates. They provide flexible solutions for persistent skill shortage, especially in regional areas. When we use it, access same skilled roles, so concrete workers, plant operators, they are on the occupation list, right? Concessions, like I said, you can get concessions for those workers. Age, under the normal 482 visa, there is an age limit of 45 years old to apply for permanent residency. With the labor agreement, you can negotiate that. English, there is an English requirement for 482, around 5 on IELTS on each band. IELTS is an English language test. Um, so you can request lower English test or even no English, right? Salary, some have concessions up to 10% below Chismit in case by case. Depends on the situation and the type of labor agreement you are considering. Company specific. So the company specific agreement, labor agreement, is negotiated between individuals, employers, and the Australian government, um, allowing businesses to sponsor overseas workers in specialized or how-to-fill roles not covered by the standard visa programs. They are ideal for employers who have a unique labor agreement unmet by existing visas, can't find suitable local workers despite genuine efforts, require workers with niche or specialized skills, are willing to meet strict obligations, including training and fair pay. Terms such as eligible occupation, English levels, salaries are tailored to each business with strong evidence and labor market testing required. Um, Amongst all the labor agreements that exist, these are the ones that the company specific, it's the one that suffers more scrutiny, but from the government, because it relates to your company, as the name suggests. So you really need to show a strong business case as to why you need those workers, and why you can't source locally, right? Um, so it's different situation with other type of labor agreements, so we're going to cover later. But still possible. Mostly, these ones are most suitable for large companies as opposed to small to medium. And yeah, you need to show a really strong business case for the workers, and there is a huge involvement with unions and the government, etc. So yeah, it's a pathway less common than the others, but still valid. Um, Dharma, it's more common and because and less stricter compared to the company specific, and that is because the government already identified the skill shortage in the regional areas, and there is a pre-draft labor agreement already, right? So um, the occupations are not on the list, and you still have those concessions about age and etc. Age, English, and skills. But because they're already being identified as skill shortage in the area, that's sort of they facilitate you getting into agreement with the regional area. Right? How this helps your business. So key benefits for employers. It can secure long-term employees, right? So overseas hires are often seeking long-term opportunities. Access dedicated and skilled labor. These candidates bring essential skill qualifications and strong work ethic tailored to your business needs, enhancing regional workforce stability and cost-effective hiring as well. As long as the salary is above Chismit and the possibility of the marketplace, business can manage payroll predictably without excessive overheads. Um, and just one thing about Dharma is the negotiation is made between you and the Chamber of Commerce from that regional area. Um, we are fortunate to have a lot of clients in that space, and I actually find this relationship and this uh, negotiation with these chambers of commerce to be um, very productive. They are very approachable and understanding that your employer, your client needs a solution. So it's every time we have clients um, for labor agreements in regional areas, it's a pleasure to help them because and also work with these chambers of commerce in order to get applications approved. So um, in the very rich, as opposed to the Department of Home Affairs sometimes with 482, which is um, you know you can't speak to anyone or can't talk to anyone. Like these chambers of commerce, it's a different story. Um, okay, so there's been an update that's going to take place in a matter of few days. They released this in the form of an instrument, um, but they haven't worked out the policy yet around the explanation around. Um, but essentially, it's previously some workers count experience with non-sponsor employers towards the 2-year requirement. So what that means is um, for you as an applicant, as an employee, as a visa holder, to apply for permanent residency, 2 years of working in that occupation, you could count work undertaking with a different employer as long as it was in the same occupation and you were doing the same thing, right? That employer, yeah, could be didn't have to be an approved sponsor. So they changed that. So work experience undertaking with an approved sponsor counts towards the 2-year requirement. So it's only if your employer, your employer is an approved sponsor, then you can count the work experience with that employer, right? Um, so strict informers. So if a worker floats to another site or employer who has an official intake of the nomination, that clock stops, right? So it's not that you are not allowed to work for another employer in case of a termination or you decide to resign or redundancy. You can. You can go to a different employer, but that time will only be counted towards your 2-year permanent residency eligibility if the employer that you're going to work next is an approved sponsor business. Skill in demand. This is very interesting because from November now, the minister has expanded his powers to cancel 482 visa, which is called SID visas, SID visas, if they sponsor breach obligations. So the minister has powers under the Section 116 of the Migration Act to cancel visas on a discretionary basis in lay terms, but this change in the legislation has given them extra powers to cancel 482 visas for that reason. Even if they sponsor breach obligations, or even you as a 482 visa holder breach obligations of your visa by, I don't know, no securing another sponsor within 6 months, for instance. So it gives them a little bit more power to cancel visas now, where they didn't have before. Primary versus secondary. So clarify definitions about primary and secondary applicants and how they are strictly tied to the primary visa holder employment status, right? So they call these reform technical measures. So what this means for employers is set and forget is dead. You must actively manage nominations. And if you acquire a worker from another site, you must transfer the nomination immediately. Delays now risk the API eligibility or sponsor status as well. So while there is some allowance with the 6 months, that time won't be counted towards permanent residency. And for these 482 visa holders, permanent residency it's what they attract them in the first place for majority of them. So if they're losing time, or if they don't cannot count their work experience, then their role might not be attractive for them, and you may lose talent. Um, so you need to act fast. Like before, used to you could take a time, but when it comes to PI eligibility, then you need to act fast and nominate your employer at the first earlier opportunity. Yeah. Okay. Getting to a Q&A session now. Does anyone have any questions? Okay, I'll take that as a thank you, Mike. Thank you. Um, at No Borders here, we offer free consultations. So if you want to explore available options to you, to your business, or to your employees, feel free to um, scan scan the QR code, and that will lead to our website, and then you can book one of the free consultations, whether you're in Brisbane or Sydney or Adelaide. Um, and as part of the free consultation, we assess the eligibility for 482 visa, and see whether we can assist you, right? So they're entirely free. There is no strings attached or anything. So yeah, I'll just leave a few more seconds here so people can, whoever is interested, to scan the QR code. Otherwise, you can still go to our website, or call us or email at info@nobordersgroup.com.au. So thank you, everyone. I hope it was informative and not too boring. The employed skilled visas are my area of expertise. I've been doing this for many, many years. It is something that you need to be aware of, not the current situation is and the legislation is, but also new trends, right? And what the department is heading and what they think. So I think that's what most of our value is to, because we've been dealing with the department for many years, so it's we understand how things work generally. So thank you, everyone, and look forward to speak to one of you guys in a free consultation. Thank you.